Hello, my name is Jamie Burgess, and thank you for choosing to watch my project on covert government surveillance. From tinfoil hats to tiny microphones, from wiretaps to drones, covert government surveillance has captured the imagination of conspiracy theorists everywhere. However, the real question as to whether or not these government activities are ethical is truly a matter of which takes priority, the right to privacy or national security. I've started off our informational journey with a little bit of the theme from the X-Files, a popular television show in which the activities of government entities are portrayed as decidedly unethical and even in some cases completely antithetical to the safety and security of the American people. There are two major reasons why the government engages in covert surveillance operations. First, to detect and apprehend criminals, including organized crime figures, and more recently, terrorists. Secondly, to increase national security by monitoring communications by suspected terrorists, both international and domestic, foreign spies, or other individuals or organizations that might present a threat to American interests. The ethical considerations among government surveillance are primarily centered around the Fourth Amendment to the Constitution of the United States. The Constitution and its amendments are examples of social contracts, where the document codifies the agreements between the members of society and its governing body, in this case, the federal government. The Fourth Amendment guarantees the right to privacy and defends against search and seizure without a warrant. It also specifically states that warrants can only be issued based on probable cause, and a warrant must be clear in regards as to what is to be searched and what can be seized. In court cases which are based on the Fourth Amendment, there are three major questions which the courts must consider. First, does a government activity constitute search and seizure? Secondly, what exactly constitutes probable cause? And finally, what actions or restitution should be demanded if a governmental agency has violated the Fourth Amendment rights? There are a variety of U.S. Supreme Court opinions in court cases that address covert surveillance by the government in terms of possible violations of Fourth Amendment rights, and these opinions have evolved over time. Wiretapping, which is defined as intercepting telephone conversations, originally began in the 1890s when telephone usage began to become common. The New York City Police Department listened to conversations between lawyers and clients, priests and parishioners, and doctors and clients, and even tapped into hotel phone lines to listen to hotel guest conversations. This was in direct violation of New York state law, which had made wiretapping illegal in 1892. During Prohibition, wiretapping was a valuable legal tool in collecting evidence against bootleggers. Roy Olmsted, a bootlegger in the Seattle, Washington area, was convicted using evidence obtained through wiretapping. Olmsted appealed his conviction all the way to the United States Supreme Court, which did rule against him, but in a lopsided ruling of 5-4 against. The prevailing opinion stated that the Fourth Amendment only guaranteed protection for tangible assets, and wiretapping was not a physical search, and nothing tangible was seized. However, Justice Louis Brandeis issued the opposing opinion, stating that Fourth Amendment protections ought to be extended to electronic communications by stating, whenever a telephone line is tapped, the privacy of the persons at both ends of the line is invaded. In 1934, Congress passed the Federal Communications Act, which included a provision that made it illegal to intercept and reveal electronic communications. Several years later, the Supreme Court used this act to reverse its original position regarding wiretaps, and ruled evidence gained through warrantless wiretaps was inadmissible in court. The Attorney General subsequently declared that the FBI would cease wiretapping. However, after World War II broke out, J. Edgar Hoover, director of the FBI, argued that the ban on wiretapping should be withdrawn. In addition, he stated that the Federal Communications Act prohibited intercepting and revealing conversations, so intercepting without revealing was permissible. President Roosevelt agreed with Hoover on the condition that the wiretapping was minimal and focused on communications between aliens, meaning foreign nationals. Because information gained through wiretapping was inadmissible in court, the FBI began to keep a secret set of confidential files. The FBI's secret files contained information gathered from illegal wiretaps of various government figures, including senators, congressmen, and Supreme Court justices. Hoover may have used this information to discredit any politicians who were trying to limit the power of the FBI. This information was also used during the so-called communist witch hunts led by Senator Joseph McCarthy.
At the start of the Cold War, President Harry S. Truman needed to create an international spy agency to counter the Soviets. wanted the FBI to take responsibility for both foreign and domestic spying, just like the KGB.
Now, J. Edgar Hoover was the innovator when it came to information collecting. And he said, well, because I'm the innovator, because I'm doing this so much better than anyone else, I should also be able to run the international side of things.
Well, Truman understood how Hoover used sex to undermine the constitutional order. In 1945, he wrote, "We want no Gestapo or secret police. FBI is tending in that direction. They are dabbling in sex life scandals and plain blackmail when they should be catching criminals." Truman did not think that Hoover should have any more power, so he created the CIA with responsibility for foreign intelligence.
The formation of the CIA and making it so that the FBI and J. Edgar Hoover couldn't do both domestic and international investigation was a big blow to Hoover.
Hoover never forgave Truman and started leaking information about alleged communists in the Truman administration to young Congressman Richard Nixon and Senator Joe McCarthy. Nixon and McCarthy rose to national prominence, bashing the Truman administration for being soft on communism. J. Edgar Hoover was the true creator of McCarthyism.
Bugs are small hidden microphones which are capable of recording and or transmitting audio and nowadays even video feeds. Charles Katz was a gambler who used public telephones to place his bets. The FBI had placed a bug on the outside of the phone booth to record Katz's conversations, and he was subsequently convicted of illegal gambling. During his appeal to the Supreme Court in 1967, the prevailing opinion clearly stated that the Fourth Amendment protection extended to people, not just places or objects, and electronic surveillance of citizens without warrants was illegal. Justice Potter Stewart wrote that what a person seeks to preserve as private, even in an area accessible to the public, may be constitutionally protected. During World War II, the U.S. government censored all telegram traffic entering or leaving the country. At the end of the war, this was shut down, but the Signal Security Agency sought to find a new way to get access to this traffic. It asked three major corporations, Western Union, ITT, and RCA, to allow it to make photographic copies of all foreign government telegram traffic. The companies agreed in the interests of national security. The SSA called this Operation Shamrock. In 1952, the SSA became the National Security Agency, or NSA, and began to use Operation Shamrock to monitor computer traffic by searching for keywords. In 1962, Robert F. Kennedy, then Attorney General for the United States, developed a watch list of hundreds of alleged organized crime figures, and Operation Shamrock was used to monitor telephone and computer communications of the individuals on the watch list. During the Bay of Pigs crisis, U.S. citizens and companies doing business with Cuba also had their communications monitored by the NSA, which sent the information to the FBI. During the Vietnam War, both Johnson and Nixon believed that foreign governments were involved in influencing anti-war protests in the United States, and asked the NSA to place the names of various anti-war protesters on this NSA watch list for monitoring. Nixon began his war on heroin in the late 1960s and utilized the NSA to monitor the communications of suspected drug dealers as well. However, under pressure from both a hostile Congress and the press, Operation Shamrock was finally shut down in 1975. The rise of email communications in the 1990s led the FBI to develop a monitoring system termed Carnivore. The FBI would serve a warrant to a particular internet service provider to intercept emails of a suspect. However, instances of FBI demanding access to emails without warrants occurred, and eventually one ISP provider, Earthlink, filed a legal challenge in court in response to one such demand. The challenge was denied by the U.S. District Court. Eventually, Carnivore was replaced by commercial software capable of carrying out the same function in 2001. After the events of 9/11, wiretapping and other monitoring of electronic communications by the federal government rose sharply. The passing of the Patriot Act in 2001 specifically allowed the U.S. government to implement roving wiretaps in order to detect, monitor, and prosecute suspected terrorists. Computers and cell phones were targeted, and the public sentiment and hovering fear of terrorist attacks gave tacit approval to these activities. However, these wiretaps could be implemented without warrants, thus eroding the current protections against the right to privacy. The National Security Agency has claimed that several al-Qaeda plots were foiled by information gathered through these wiretaps. In 2010, the Federal District Court in San Francisco ruled these activities illegal, but the Obama administration has filed an appeal, and the court case is not yet resolved. In 2001, the U.S. Department of Defense created a database called Talon to collect reports of suspicious activities or terrorist threats near military bases. However, in 2005, NBC News reported that the database contained emails from students planning protests against campus military recruiting activities. And eventually, the Department of Defense conducted an in-house review of the contents of the database and pledged to purge all information not directly related to terrorist activity. The American Civil Liberties Union asked Congress to take deliberate steps to ensure that Americans may once again exercise their First Amendment rights without fear that they will be tracked in a government database of suspicious activities. In 2007, the Talon database was shut down. However, electronic surveillance by the NSA continues, as reported by the Washington Post in June of this year. Under the proclaimed mission of monitoring for suspected terrorist activity, the emails of ordinary citizens have been read, perhaps even yours and mine. In Oregon, federal judges upheld a challenge to warrantless wiretaps, but did declare government no-fly lists as unconstitutional. The development and increased use of unmanned aerial vehicles, also known as drones, has become a very recent topic of concern. Drones are small and can be used to monitor homes and business offices, even several stories off the ground, and have the capability to be fitted with tear gas canisters and can even fire rubber bullets for use in crowd control. There is currently a great deal of debate regarding their use, and there exists little legal precedent or case law regarding their use at this point in time. I'd like to leave you with a quote from George Orwell's classic dystopian novel, 1984, which foresaw many aspects of today's society with chilling accuracy. In the novel, government surveillance is rampant and accepted part of society, with government cameras recording the every move of its citizenry. We now see cameras everywhere, from ATM machines to traffic cameras to sophisticated security systems in banks, offices, and transportation hubs such as airports and train stations. Who knows how much of these are being utilized for covert government surveillance? How do we balance the need for security versus the need for privacy? In Orwell's novel, the need for security has completely overcome the need for privacy in the name of freedom. Will we as a society make the same choice?